Ladies and gentlemen, there's a very famous Latin proverb that essentially asks, who will guard the gods? In India, it can best be interpreted as, who should make the laws for our lawmakers? Today, the centre has made it very clear that it is Parliament and not the courts or any other institution that decides laws on their behalf. Which may make sense when you keep in mind that the law in question talks about whether an individual is socially and morally fit to represent you in Parliament or a legislative assembly to begin with. Yes, of course, we are talking about the Representation of People's Act, a critical law that disqualifies any politician convicted in a criminal case to a sentence of 2 years or above from contesting elections for a period of 6 years from the day the individual walks out of jail. Essentially, if you have been convicted in a criminal case, as soon as you walk out from that period for the next 6 years, you can't contest an election. It's a rule that has forced many a criminal netas to resign as MPs or MLAs, from the Samajwadi Party's Azam Khan to the BJP's Kuldeep Sengar, and most famously, of course, the RJD's Lalu Prasad Yadav. It has even been a law used to target headline names such as Rahul Gandhi and the late Jayalalitha and get them to demit office as MP or even Chief Minister until their conviction was stayed by a higher court. Now, the Supreme Court is hearing a petition which seeks to make this act even stricter by changing the maximum period of disqualification from 6 years to a lifetime. Essentially, if you have been convicted in a criminal case, you are barred from the Legislative Assembly and the Parliament. Essentially, the petition says if an MP or MLA has been convicted in a criminal case, then he or she should be barred from ever contesting an election. But the centre, which was asked to give its view by the Supreme Court, has come out very firmly against the proposed amendment, claiming it would be disproportionate, unreasonable, and requiring undue haste. Moreover, the centre insists that only the legislative should be allowed to make and amend laws, not the judiciary. Essentially, the centre is saying, making laws is our business, not yours. Amending laws is our business, not yours. Well, perhaps this will give you a cue as to why our netas don't want to have a sword of disqualification hanging over their necks. Just look at this data. A whopping 251 MPs, almost half of the current Lok Sabha, are facing criminal cases today. This is the highest ever the lower house of Parliament has ever seen, a record of sorts. 170 of them are facing serious criminal cases. And by the way, they represent all major political parties. And when I say serious cases, by that I mean rape, murder, kidnapping level serious cases. The scene is fairly similar in the Rajya Sabha, where 33% of the House is facing criminal cases, and in the state assemblies as well, where a cumulative 44% of all MLAs are facing criminal cases. With these facts in mind, we are asking today, can netas be allowed to formulate and protect laws to protect themselves? Is it time for a fundamental rethink of accountability in our political system? When you and I will be shunned from all professional and personal life decisions if we are ever convicted as criminals, why should politicians be above this moral standard? Let me put that question to my guests who are joining me this evening. Jagdeep Chhokar is a co-founder of ADR, joining us on the broadcast. Tehseen Poonawalla is a political analyst. Aditya Pratap is an advocate. Shashank Shekhar Jha is a lawyer at the Supreme Court. Manish Bariyar is a political analyst. He mostly represents the BJP today. I wonder what position he is taking. But Jagdeep Chhokar, can I come to you first and ask you what you make of the centre's defense that they have come out with this, actually not the defense, the centre's opposition to a lifetime ban on netas if they are convicted. They are saying 6 saal kafi hai. Zindagi bhar ke liye you don't need to ban netas. So what if they've been convicted?
The centre's response is not unexpected at all. This issue has been going on for 25 years. as far as I know, because I've been in this activity for 25 years. In when the Supreme Court said that candidates contesting election should declare criminal cases pending against them, even then the Parliament had unanimously amended the Representation of People Act to prevent that from happening. And the Supreme Court then ruled that that amendment to the Representation of People Act was unconstitutional. Now, since then, there have been, at a very rough count, at least 10 petitions in the Supreme Court saying that people who have been convicted of serious crime should not be allowed to contest elections. And Supreme Court has repeatedly beseeched and exhorted the Parliament to make a law to this effect. And the Supreme Court has used very evocative terms that the nation awaits action by the Parliament, etc., etc. Nothing has happened. There is a well-established legal principle which is called filling in the gap in the legislation, which says that if there's a gap or a lacuna in any legislation, and the Parliament has not had the time or inclination to fill that gap, and the most important condition is the third one, public interest is suffering, then the judiciary has a right and a duty to fill that gap in legislation till the legislature does it. This principle was used by the Supreme Court in 2002 in our own case on disclosure of criminal antecedents. And this principle of filling in the gap in legislation has been used many times, and it is a well-established principle. Now, in this case also, what the Supreme Court is being requested to do is that since the Parliament has not felt it appropriate or it has not had the time or inclination to make such a law, the Supreme Court should fill this gap and correct this lacunae till the Parliament acts on it. So let the Supreme Court rule, and if the Parliament is not happy with it, let the Parliament undo it, and then we will see what happens.
Shashank Shekhar Jha, you're someone who practices in the Supreme Court. I want to ask you what the legal argument possibly can be if there are citizens who are going to the court and saying you cannot have different moral standards for the Aam Aadmi and for the Neta. If a Neta has been convicted in a criminal case, we are not saying defamation case, etc. वो तो चलता ही रहता है इन लोगों का. But if a Neta has been convicted in a criminal case means what? Murder, kidnapping, rape. If a guy like that has been convicted by a court of law, why should he be allowed to fight the election ever? Why just ban him for 6 years? How's this justice?
Shreya ji, namaste, and namaste to my fellow panelists here. Shreya ji, there are 2-3 aspects here. Point number one, it is a very good argument whether they should be allowed or they should not be allowed even after the cooling off period of 6 years after the completion of conviction. However, who will decide whether they should be allowed or not? It should be Parliament, because they are answerable to the people of this country, and there are 545 odd people in Lok Sabha and 250 odd people in Rajya Sabha representing the voice of this nation, who will be having more ears and more resources with them, who will be deciding on this issue. So it should be with the legislation who will be deciding on this issue. Second part, just 2 days back, Honorable Supreme Court has said that Lokayukt cannot adjudicate the corruption charges on High Court judges. So when Honorable Supreme Court says that High Court judges and Supreme Court judges are different from other personalities, that way even Member of Parliaments and Assembly leaders are different from normal people. So if you are deciding for your own people, let them decide for their own people. And this can be one of those arguments. My point is, I am not defending or objecting to this point. Be it 6 years, 60 years or 6 months. Who should decide this? We as a people of this country are choosing these leaders to represent us before Parliament. Parliament can make a law for them, for the member of parliamentarians. Now 6 years is a gap which has been created by Honorable Supreme Court itself. So the fellow gentleman who was speaking before me has said that the Supreme Court can fill the gap. The gap was filled by Supreme Court itself. Now the demand is that you should fill more gap. So if Supreme Court is willing to fill more gap, it should have equality for everyone. They cannot have different yardstick for Supreme Court and High Court judges versus member of parliaments and member of legislative assemblies, because both of them are constitutional machineries doing their own respective jobs, and this will again dissolve the doctrine or the separation of power between legislative and judiciary, which will create a law and order situation which we have seen during Indira Gandhi regime. So if in case this matter should be treated, it should be treated only by the
But there is a law and order
parliamentarians
situation
who have
facing
this
our
authority
parliament.
as per the Constitution of India.
Mr. Jha, if you look at the numbers, it seems that our parliament
Yeah, so
already
for the-
has a
for
law
the
and order
law and order
situation.
situation, that is
Look
why-
at the numbers, and Hannah, and we'll put those numbers on our screens. 251 MPs in the Lok Sabha are facing criminal cases right now. 170 of them are facing major serious criminal cases, rape, murder, kidnapping. 33% of our upper house is facing, has convicted, not convicted netas, but netas who are facing criminal cases. 44% of our MLAs across this country have criminal cases. अगर आपने आधे क्रिमिनल भर रखे हैं अपनी लेजिस्लेटिव असेंबलीज में और अपने पार्लियामेंट में, why will they make a law which will say, okay, if they are convicted only 6 years, after 6 years they can come and fight an election again and come back to the parliament?
Shreya, I'm so sorry. Merely having an allegation on you does not make you a convict. See, these 250 MPs and other numbers which you have given, I will not doubt that. But these are mere allegations. The cases are already going before independent judiciary. My point here is very clear. See, earlier, those convicted people used to be in parliament and assemblies. Supreme Court passed a law. Thereafter, Lalu Yadav and likes of Lalu Yadav are unable to come into parliament and assemblies. They have this limited period of 6 years. So you need to understand that Indian judiciary or Indian legal system works in such a way that we need to remove the criminal activities. We do not want to kill all the criminals. We want to remove the criminal activities. So if suppose someone is convicted, undergoes his judgment or her judgment, and thereafter do this cooling off period, and thereafter returns to people of this country and get elected, why to stop them? And if you want to stop them, who will stop them? People of this country should stop them, either by vote or through parliament. Why should judiciary come into this aspect? Because judiciary doesn't have the power to formulate law in this country as per Constitution of India. It is merely acting as a guardian of Constitution. It is not the Constitution.
Okay, I take one point very positively that you have put out, Shashank. The fact is that if judges in this country have an allergy of being themselves investigators, in this case by the Lokayukta, then should they be talking about parliamentarians facing a lifetime ban if they are convicted? That's a good point you raised. But Aditya Pratap, would you want to respond to Shashank Shekhar Jha's argument? And he makes a very solid one, by the way.
See, if you see when His Lordship, the Justice Dipankar Datta's bench issued notice in the petition, it said that there is a major conflict of interest in allowing a lawbreaker to become a lawmaker. Section 8, as it is apparent on the record of the Representation of People's Act, clearly says that after the conviction ends, after the imprisonment ends, for 6 years he should be disqualified. However, please keep in mind the context at the time at which this law was passed. This law was passed in the year 1951. We have the Representation of People's Act 1950, and we have the Representation of People's Act of 1951. At that time, criminals in the legislative bodies and the parliament used to be an exception rather than the norm. But as the figures given out by you indicate, that now criminals in politics has become the norm rather than the exception. So which is why, what is the object of the law? The object of the law is deterrence. Because ultimately, as the saying goes, that be you ever so high, the law is always above you. And when you allow a person with criminal antecedents to contest elections, because see, what is basically, because try to understand that when a person serves out a sentence, he regains his freedom. But then public office is a privilege. You are giving that person several parliamentary privileges. You are giving him the power to make law, so the point is, the court, it is within the freedom of the jurisdiction of the court, and especially the Supreme Court also has inherent powers under Article 142 of the Constitution of India to even entertain this petition and pass substantive orders where it feels in cases where justice would not adequately be served. here, because the question is, if you look at the law, 6 years is the time period of disqualification. The point is, has this period deterred criminals in politics? Unfortunately, not. It may serve to disqualify individual politicians, etc. But then when the rising trend is seen, it is very much evident that the number of criminals, and as you said, 46% Lok Sabha MPs facing criminal cases. So the point is, when the court decides such cases, it also sees what is the object of the law. The object of the law was to essentially ensure that criminals don't enter politics. And plus, the conflict of interest is very much evident here, because ultimately this is the same government whose bulk of any government, be it the opposition, be it ruling party, when the substantive number of members have criminal antecedents, then one cannot expect a fair response from them. They are bound to oppose such a petition, and they're likely to even oppose.
Okay,
such
this is
measures,
a conflict of interest, you're saying, in any case.
Yes, it is a conflict of interest.
Okay, I understand
Like
what you're saying. You're essentially saying this is a conflict
Yes.
a conflict of interest. Also, Manish Barrier just coming in. Tehseen, give me a moment. Let me hear the other point of view. Manish Barrier, is this a conflict of interest? Because it certainly looks like a conflict of interest. The argument that Aditya is making is times have changed. 20 years ago, 30 years ago, we didn't have as many people with a criminal record entering our parliament like they are entering now. And therefore, the rules have to be stricter. It'll act as a deterrent. What could be, what's the argument against it?
Good evening, Shreya ji. Good evening, Shreya ji, and good evening to my co-panelist and all the viewers.
Good evening.
See, I would like you to, and everybody to look at from a different perspective. In fact, before answering that question, earlier when I was young and actually I was not visiting villages, I would always feel with a lot of disdain that how so many criminals are coming up. And obviously, I'm not justifying what's happening, but people who are at ground level, a lot of journalists you will ask, and they will tell you that the journey of a politician is fraught with dangers and counter cases, and number of false cases are there. So you have even people like Nitish Kumar facing criminal charges at early age during his formative years. So you have number of people, it's happening. And it's happening in villages like anything. So it's very, very difficult for a budding politician who is into electoral politics to actually not face these kind of charges. And this, I think the lawmakers of this country and the top politicians from, I think, either side of the divide, they are seized with this matter. I think we should look at this entire thing from that context. When you say that lawmakers are the lawbreakers, I think this is very, very harsh. Because a lot, as Mr. Shashank said, that most of the people who get into legislative assemblies or in parliament, the cases are under them, right? They are not convicted criminals, and there is the punishment has to be proportional. I think you have to also give the way you give the normal people to reform and to come back to the society and join their mainstream and to do jobs. For a politician, their job is also to contest election, and we should be leaving it to the country, the wisdom of the people of this country. If people feel that this person is not fit to be in parliament, they would never be found in the parliament. I think this is what my understanding would be.
Okay, Tehseen, do you buy this argument? Leave it to the wisdom of the people. They know that this guy has been convicted. And by the way, Mr. Barrier, I wasn't talking about people who are charged or who have cases against them. Of course, a lot of false cases get filed against politicians. I was simply talking about politicians who have been convicted. So that is a distinction that we need to make. But Tehseen Poonawalla, does this argument hold? Janta sab janti hai. Leave it to the wisdom of the janta. Leave it to the wisdom of the voter. They know that the guy has been convicted in a murder case or a rape case or whatever case. If the guy wants to come back and fight the election, and if the people are okay voting for him, who is the law to stop them from coming into parliament?
Thank you, Shreya, for having me on the show. Thank you, Shreya, for having me on the show at the onset. A very happy Mahashivratri to you, to all my fellow panelists, to all the viewers of Mirana, and to your families. There are two aspects here, and I tend to lean on the side of what Shashank Shekhar Jha and Manish Barrier are saying, though I'm fiercely anti-BJP. So there are two aspects out here, and I just like the patience because it's extremely grey. First, I do support the Honorable Supreme Court's judgment to be appalled and shocked at the guts of a Lok Ayukta to try and investigate judges. It was shocking, and the harm done to India by that Anna Hazare group is tremendous. Pakistan has something called an NEB, which is unaccountable. Do you want that in our country, that judges are going to be investigated by people like in the Lokpal and Lok Ayukta? So I'm grateful that the Supreme Court was shocked by it and threw it out. But now coming to this, it's equally shocking that the Supreme Court decided to use its arbitrary powers under Article 142, which many a times is used arbitrary. It does a lot of good work under Article 142, the Vishaka guidelines, etc. But they've also changed BCCI under that to hear this case. When I'm in government, I will make laws. Who are judges to make laws? Can I tomorrow, when I'm in government, when I'm sitting as the Home Minister of the country, if I'm the Law Minister of the country, call a Supreme Court judge inside Parliament and say, we are not giving judgment fast, so Parliament will pass the judgment? Making laws is my domain, not a court's domain. And this moralistic argument is so wrong, so wrong. Let's take the example of Lalu Prasad Yadav. He's convicted for 2 years. Plus 6 years, Lalu Prasad Yadav cannot contest an election. Good, bad, ugly, if he contests after 8 years, people of India can select him or reject him. That is a democratic process. But let's say somebody else convicted for 2 years. After a gentleman comes out of jail for 2 years, 2.5 years, he can get a job. No law prevents the person from getting a job. Here you already have a law that is preventing Laluji from contesting an election. This is anyways arbitrary and unfair. Having said that, Parliament in its wisdom can decide whether to strengthen the law or to reduce the law. That once Parliament does, the people of India can decide to vote for the political party or throw it out. But to courts to sit that, oh, there is a lacuna, so we will sit in judgment. Who will judge the judges? Will the judges agree to the National Judicial Accountability Commission? Will they allow that the way they appoint judges to their system will be transparent, and now Parliament will appoint judges? Maybe in consultation with courts. There they want to fiercely guard their independence, rightly so. But here they are stepping into the domain of what is the role of the Parliament, the legislator. It is not their job to see. If Parliament frames a law which is unconstitutional,
Tehseen, all that is very well. Tehseen, all that is very well.
One second.
If the matter was even to be debated in Parliament, give me a minute. If the matter was even to be debated in Parliament and put to vote, if our Parliament has the number of Netas facing criminal charges, I'm not saying convicted, but facing criminal charges, why on earth will they support the bill? Please tell me.
All right, let me flip this around.
Which is why maybe the Supreme Court needs to step in.
No, 1 second. Let me flip this around and ask this. So, all these judges appoint their friends' kids as judges. Parliament needs to step in. Their courts will say no. Look at your judges. Everyone are from a family. Everyone are from a family. Everyone are 90-95% are from a family. Parliament needs to step in. There you will allow Parliament to step in. See, if these parliamentarians are passing laws that are ultra-vires to the Constitution, the court has all the powers to strike it down. Number two, if they are passing laws that protect their interests, the people of India have the power to throw these parliamentarians out. But making laws is my business. A judge who's unaccounted, unaccountable, unelected, unelectable will sit on me, elected by 50 lakh people, 1 crore people, and tell me that a law passed, not ultra-vires to the Constitution, is not proper because the judge sitting in his ivory chambers feels it's not proper. I agree, if the law I pass is ultra-vires to my Constitution, it should be struck down. Article 142 was used to change the BCCI. Is it justified? I'm asking you these questions. Courts have to draw the Lakshman Lekha. Judges are not the masters of our country. The first 3 words of our Constitution are we the people. We the people will decide who goes to Parliament. We the people will throw them out. Judges can strike down laws made by we the people that we the people elect.
Okay, Jagdeep Chhokar, I'll give you the last word. Ultimately, it comes down to we the people. If we the people, and this is the argument that has been made by at least 3 panelists on the show, if we the people are okay with re-electing a Neta who has been convicted, what problem should anyone else, especially the Supreme Court, have?
Well, give me half a minute to explain. We the people have a very limited choice. If all the major political parties put up candidates which have criminal cases pending against them, what choice do we, the people, have? We actually do an analysis which is called red alert constituency analysis, where 3 or more candidates have criminal cases pending against them. And more than 50% of constituencies are like that. Now, I am just curious. I mean, we have a lot of problems with the judiciary, and I agree with them. But does the judiciary have 46% judges who have criminal cases pending against them? Everybody wants to make laws for himself. Doctors want to make law for doctors. Judges want to make laws for judges. Politicians want to make a law for politicians. Nobody wants to make a law for citizens. Citizens have nowhere to go. Citizens go to the court when they find that over 25 years, this problem is persisting and the parliament has not had the time or inclination to deal with it. So 25 years is not a short time, at least in my opinion. And if the parliament does not listen to the people for 25 years, where do people go? People go to the court. Court have a right to correct the law, and the parliament has the right to again undo the law. This is the process which is laid down. What is the problem in following that process? Let the Supreme Court decide. If the parliament thinks the Supreme Court has overstepped its authority, let the parliament make a law. Again, it will go to the court. And I mean, this is the constitutional process that we need to follow. What is the problem in following it? I don't understand.
Okay. Tehseen wants to come in. Tehseen, very quickly.
We are slipping down a very dangerous spiral. Very dangerous spiral. The day won't be far when Shashank, me, Manish will be here, and the courts will summon the Prime Minister of India to the court, like it happened in Pakistan. How dangerous is it? We will not be a democracy. This is the most dangerous argument to be made on moral. The law is clear. If you're convicted, plus 6 years, you cannot contest. Who is parliament? What is the difference between 6 years and 8 years? Who decides? A judge sitting? What gives the judge the expertise? I'm seriously asking you. How does Article 142
But there's a lot of
difference
difference between 6 years. No, 1 minute. There's a lot of between 6 years, 8 years and a lifetime, na? Which is why the matter is being debated.
So when you're talking about a murder charge or a rape charge, I'm presumably talking about that. That conviction anyways is not less than 10 years. So 10 years plus 6 years, 6 years is anyways a lifetime. It's not direct, it's indirect. Now a judge, because he's sitting there or she's sitting there, will decide, no, I will do something else. But can the judge, who himself is there because of his family connections, be accounted for? These are the questions. We have to ask these questions. If courts summon parliament, what if courts going to summon the prime minister like they did in Pakistan? They summoned Nawaz Sharif for some moral issue. It wasn't even a legal issue. Is that what we want in our country? Is that what we want courts to do? Summon the prime minister. I'm anti-BJP, but tomorrow when I'm in government, I want the courts to summon my prime minister for what? You can't allow this in the country. There has to be a Lakshman Rekha, a very thick Lakshman Rekha, may I say.
Shashank Shekhar Jha, you wanted to come in as well. I could see you raise your hand. Go ahead, please.
Shreya, there has been few significant changes in our legislation also by the Supreme Court, which has been honored by everyone. One, in every election, every candidate will have to give their criminal record, the allegation against them, the cases pending against them, etc., etc., and they will have to advertise, promote it over their website, including the political parties. So that has been supported. Second point, special MP MLA courts will be there to investigate on those MP MLAs who are being accused of some crime, like the data you are giving here. Now my point is, the allegations, if they are very serious, for example, rape, murder, etc., like Tehseen was saying, then there will be life imprisonment. They will not be able to return back from their life behind jail. Now, those who are convicted between 2 years to 10 years or 12 years, they can get a cooling off period of 6 years, and then they can try to return back to the normalcy. So doesn't our judicial system, which is based on dharma, because the Supreme Court's motto is yato dharma tato jaya, where there is dharma, there should be victory. So what does that mean? That means that the evil should be removed from the society. So if someone is giving a judgment to be behind bar for certain years, It is because the society wants to reform that person. So if a reformed person wants to return to the society, why are you stopping the person? Do you want the person to be returned to that problem again?
Acha, chalo, Shashank Shekhar Jha, will that hold true for a bureaucrat, for an IAS officer, for an IFS officer as well? Bataiye. Someone is convicted for corruption or murder. Will the government, after 16 years, allow that bureaucrat, that IAS officer, that IRS officer to come back and join the government? To say that, you know, this guy has reformed, he needs to be given a second chance? If that bureaucrat is not given a second chance, why should a Neta be given a second chance?
Shreya ji, difference है. जो bureaucrat का job होता है, they are there to apply for a particular job during particular age limit, etc., etc. They will not be eligible for that job. For a politician to be nominated or elected for a particular job, there is no age criteria as such. The minimum is there. There is no maximum criteria. The only eligibility is whether the people of this country wants to elect them or not. So that is why during the Constituent Assembly debate, it was very carefully drafted that a convicted person should not be returning to the parliament until unless there should be a cooling off period. You cannot compare that with any other job because it is not a job. It is a service. Technically, we the people and those people who are serving are there in the Constituent Assembly and Parliament. So we cannot actually compare that. But having said that, if you want to compare that, that liberty should be there with the parliamentary and not with judicial, not with judges who are not there directly elected by anyone. And like rightly said by Petition, Judiciary did not
that
accept
is exactly the point I'm making. Why will the parliament, which is filled with people with criminal cases against them, pass a law banning them for a lifetime? There's a conflict of interest there as well. But ladies and gentlemen, this has been a very interesting debate.
To get into their domain.
ठीक है. Okay, I know there's a question. Okay, I get your point of view. In fact, this was a very interesting debate because we managed to get all points of view in. Thank you, Tehseen. Abhi mere ko aur karna hai. Debate दूसरा. We leave it there for the moment. Thank you. Abhi दूसरा break भी लेना है. Thank you very much. Jagdeep ji, thank you very much. Tehseen, thank you. Aditya, thank you very much. Shashank, good to have you. Manish Barrier, thank you very much. This has been an interesting debate. Ladies and gentlemen, on that note, I'm slipping into a quick break on the show. Coming up next, something that has spread panic in some districts in Maharashtra. That's coming up next. Do stay with us.